be applicable to even public limited companies being unlisted, that is the concept of postal ballot. Now certain items if you are required to undertake, then you are required to do a postal ballot, and in detail the procedure for e-voting. Besides that, though it was not directly related to the topic which has been assigned to me, I have attempted to cover it. It's the criminality aspects under the New Companies Act 2013. Now you might be wondering as to why I am talking about criminal laws when we are discussing about the Companies Act 2013. But my friends, trust me, there is a very, I will not use the word draconian, but very harsh provision under the Companies Act 2013. And for us as professionals, whether we are chartered accountant, company secretaries or from other stream, it is very vital to just take note of it. Because just to throw a hint or some light at it, even let's say example, if you are going for any corporation of a company, and as professionals we have certified something, and later on it is found that that certification was not true. It might happen that inadvertently we have given something, but facts was not properly disclosed. There is a provision under the Companies Act 2013 whereby bail will not be given to the accused until opportunity has been given to the public prosecutor to present his case. Just briefly I am touching that aspect, and detail in the presentation I will be covering. So the first is section 88. Section 88 basically starts for the management and administration. It deals with register of members. Now, in my entire presentation, I have not gone much into the detail of what is there in the section and what is not there. I presume that we all are having some basic idea about the Companies Act 1956. And I have tried to highlight the practical aspects under the Companies Act 2013. And apart from that, what are the key differences between the Companies Act 1956 versus the Companies Act 2013. So as you can see, the register of members is a very basic document. And most of here I think are the chartered accountants over here. So whenever we are doing any audit or any due diligence, that is the first document we try to lay our hands or capture on it, and then we try to collect information on it and try to build our scope of work around it, whether we are doing audit or due diligence. So now you can see the register of members is required, register of debenture holders, and apart from that now there is a new requirement of register of any other securities. As you might be aware that security is a much broader term compared to the shares and debentures, and it includes literally any kind of instrument, whether it's quasi or not. So you can see under the old act, register was required to be kept only for the shares and debentures, but now for any other security also that new requirement is there. Now separately in register is to be reflected the shareholders who are in India and who are outside India. So basically when we are maintaining that register of members, a separate column is which is required for that, or bifurcating the two between the members who are in India and members who are outside. Under the old act, the index of members was required to be kept by every company having more than 50 members. However, there is no such threshold limit. So now literally all the companies will be required to have index of members. The entries in the register of members as required under section 88 of the new act is required to be made within 7 days. Under the board of directors or its committee approves the same. The register is required to be maintained at the registered office of the company unless and until a special resolution has been passed in a general meeting authorizing keeping of register at any other place within the city, town or the local limits, or other place in which more than 1/10 of the total members entered in the register of members reside. So the key takeaway from this slide, you can take it away in the ensuing AGM. We can advise our clients if we don't want to keep register of members at the registered office or for some practical convenience purpose, some other place is required. So in the notice of the AGM, this agenda item should be there before the shareholders. In case of now, this is basically next two slides will be dealing with the aspect of the listed companies and how the promoter funding is being taken by the collateral of shares. What is the effect of that and what are the compliance required for the same. In case of companies whose securities are listed on a stock exchange in or outside India, the particulars of any pledge, creation, application created by the promoters in respect of any securities of the company held by the promoter, including the names of the pledge money and any revocation thereof, shall be entered in the register within 15 days from such a date. So this is a new requirement and a new compliance for listed companies. Now there may be instances that if the promoters of any listed company, if shares of the listed company, basically to finance that gain. So for that also such requirement is there that a separate entry has to be made in the register of. Now, I don't know, just on a very lighter note, just we have completed our general election and there was a tagline by Mr. Narendra Modi, Achhe Din Aa Gaye. So generally in our Indian concept, Achhe Din means Lakpati, though in today's time Lakpati may not be a big thing, but that thing is there. So under the Companies Act has a possibility for denting us Lakpati. What I want to say basically over here, the penalties are in lakhs. So it's not like 500,000. Most of the 50,000 lakh rupees is the minimum essence of the penalty. So under the new Companies Act, it is very vital. Not only monetary penalties are there, but besides that, jail, imprisonment, all those aspects are also there. So now you can see register of members is such a small thing. If we see other work, if we are doing under the Companies Act, merger, winding up, allotment, differential allotment, compared to that when we discuss register of members, it's such a small thing. It's just a mere clerical entry, but just see the type of penalty, what is there over there. Which shall not be less than 50,000 rupees, but it may extend to rupees 3 lakhs. And where the failure is a continuing fine is there of 1,000 rupees for every day. So now there was a previously, Kaushik Bhai will agree with me, in our company secretary fraternity, especially the company used to ask what is the value addition company secretaries can do. So now Kaushik Bhai, the answer will be the saving in the cost in terms of the non-compliance. So that is the value addition in terms of the monetary aspect. So now many of you might be aware of the concept of beneficial interest, earlier section 187 of the Companies Act 1956. The new section says that where the name of any person is entered in the register of members of a company as the holder of shares in that company but who does not hold the beneficial interest in such shares, such person shall make a declaration with the company specifying the name and other such particulars as are applicable, specifying the beneficial holding in that shares. Every person who holds or acquires beneficial interest in the shares of the company shall make also a declaration specifying the nature of interest, particulars of the person on whose name the shares stand registered in the books. Third type of compliance which is there now is where there is any change basically in the beneficial interest. The person, such shares, the person shall within a period of 30 days from the date of such a change make a declaration to the company on such change. So now basically you see there are 3 levels of compliance what is required under the beneficial holding. One person, let's suppose I am holding certain shares and I am transferring the beneficial holding to Kaushik Bhai. So one have to give a disclosure to the company, second Kaushik Bhai will have to give a declaration, and the third where there is any change, at that time also further declaration will be required. So you can see now there are 3 layers of compliance what is required for the purpose of this beneficial interest of shares. Now let's assume a scenario whereby this disclosure is not given, then what would happen? Then no right in relation to any share in respect of which a declaration is required to be made but is not made by the beneficial owner shall be enforceable by him or by any person claiming through him. So basically no contractual rights will be available if this compliance is not done. Now you can see, as we have already discussed, under the old act it was only 1 layer of compliance, but now it is 3 layers of compliance. And the 4th is the company also who has to report to the registrar of companies. Now again let's come to the penalty. Fine up to 50,000 rupees and the failure is a continuing one up to 1,000 rupees for the every day. And where any declaration is required to be made to a company, the company shall make a note of such declaration in the concerned register and file within 30 days of the receipt of the declaration by it to the return in the prescribed form with the registrar of companies. If the company is failing to do so, the company and every officer of the company is in default shall be punishable with fine which shall not be less than 500 rupees but which may extend to 1,000 rupees, and where the failure is a continuing one with a fine further which may extend to 1,000 rupees for every day. Now most of us are chartered accountants, so you might be thinking if we are a chartered accountant and now there is a new concept under the Companies Act. Many of you might be aware of the key managerial personnel. And now a CFO is a person who is coming within that definition apart from the company secretaries and the managing director. So if anyone of you is a CFO over here or in your company you have a setup of a CFO, then that person in the definition of every officer, that person would also be falling. Under the earlier Companies Act 1956, there was, though you are appointed as a CFO, you didn't have any liability basically in terms of the compliance. But now that has changed, and now literally if you see CFO is equivalent to company secretary in terms of the responsibilities under the Companies Act. Now if a person is failing to make a declaration, then a fine up to 50,000, and if it is a continuing one, then up to 1,000 rupees for every day. Now let's come to the next aspect of annual return. An annual return is no longer a very simple 5-page or a 6-page form, but now it will be running for any normal company also into minimum of 40 to 50 pages. And I am talking only about a private limited company who is having a good amount of operations. I am not talking about a public limited company or a listed entities. It will be literally your annual return now is more like your prospectus when you are coming out with an IPO. It's like a Bible, you can say literally. Everything is getting over there. Each and every kind of information you can think of will be over there. So now let's see what are the aspects of the annual return which is required to be compliant. Before going to that, just small brief information to you that for this financial year what we are into, we don't have to give annual report, return as per the new act, but for the financial year ending on 31st March 2015, and thereafter the concept of this new annual return will take place. So this is one good thing that regulators has given sufficient time for all of us to understand the quantum of information what is required to be given there. Now you can see that every company has to file an annual return in the particulars as they stood on the financial year and not as the date of AGM as was in the case of the Companies Act 1956. So now let's try to just brush up on the contents of the annual return. What are the main heads under which the information is? Registered office address, principal business activity along with percentage of the total turnover of the company, particulars of the holding subsidiary and associate companies, details of issued, subscribed, paid up share capital along with the changes taken place during the year, details of non-convertible, partly convertible, fully convertible debentures along with the changes taken place during the year, details of premium of equity shares and other securities along with changes taken place therein, total turnover and net worth, shareholding pattern, category-wise shareholding with details of holding in physical and demat. It is this exact, if you see something like clause 35 of the listing agreement, you have to give in detail your entire shareholding pattern. Changes in the promoter shareholding, shareholding pattern of top 10 shareholders along with the change thereto, shareholders of directors and key manager personnel, indebtedness along with the changes if any interest details, details of members, debenture and other securities holders along with the change therein since the close of the previous financial year, details of promoters KMP along with the changes therein since the close of the financial year, composition of the board of directors at the beginning and at the end of the year with classification of promoter, non-promoter and nominee. So now you see the last thing is very vital for all those companies who are proposing to go for listing in future. Because this thing, if you are categorizing someone as promoter, then in the future if you are going for an IPO at that time, if you are categorizing someone as promoter, non-promoter group, so it's very vital to understand what are the future aspects, what type of promoter group we want to show and to do a compliance. Details of directorship of directors in other companies. Something like your 24AA, what we used to give under the new old Companies Act. Details of AGM, EOGM, class meeting, national company or tribunal or other court convened meeting and requisition meeting with details of attendance of members. So now you see when we are talking about details of attendance of members, so how to comply with it? Just details of all board and committee meeting along with the details of attendance thereto, details of attendance of all directors in board and committee meetings, details of attendance of all directors in board and committee meeting, then details of remuneration of full-time and managing directors, manager and KMPs in terms of their salary, perquisite, stock options, sweet equity and commission. Details of remuneration of other directors in terms of sitting fees and commission. Now, the new aspect, all those were new aspect, but this is very fundamental, this point to be taken note of. Details of penalty or punishment imposed on the company, its directors or officers, and details of compounding of offences and appeals against such penalty or punishment. Details of events in respect of which company was liable to file a return or comply with the requisite provision of the Act and there has been a non-compliance. So you see now the regulator has tightened the screws on the non-compliance of the company. Any person can just, let's suppose you are going for someone for a PED, you are a private limited company, right? So your profit and loss account will also be not visible at the ROC, right? But through this annual return, your compliance level will be visible. So just see what type of compliance and governance we are heading to. It is not over, there are more. Disclosure in respect of closure of registers, declaration of dividend, delisting of shares and securities, particulars of ICDs, intercorporate loans, erstwhile section 372 and new section 186. So all those details have to be captured over here. Related party transactions, section 188 of the Companies Act, it is, I think Mahavir had covered that, right? 188 related party. So it is more like your erstwhile section 297 and 314, that new 188 is like a hybrid of the two. Resolutions passed by postal ballot, furnishing of necessary information and declaration by the directors. Basically, the director is required to give some declaration, for example, 24 November, the new old Companies Act, the equivalent form, that will come. Now, though it is not forming part of my scope of this presentation, then also I would like to cover under the Companies Act there are many areas. If you see, it's something like they have drafted without applying mindly how it will be implemented. For example, there is a concept of insider trading and it is applicable to all companies. So how private limited companies will comply with it? Now let's again, I will say that there is a family settlement going on and the shares are being transferred. At that time you got some order. So what will happen to that? Is that a public information? Because when we see the whole idea of insider trading is the public shouldn't get a loss, right? Let's take a concept, there is a PE deal going on and you have done that deal. So what is the implication of that? How to comply with it? Big orders you are getting at that time, what to do? So while I am trying to cover that thing, the last one you see furnishing of necessary information and declaration by the directors. So that everything will have to be getting captured over here in your annual return. Details in respect of shares held by or on behalf of the foreign institutional investors, amount spent on CSR, limits under 186, that is loan and investment by the companies, and 180 restriction on powers of the board. Now, the next level of compliance, more or less I have tried to cover everything what will be there in your annual return. But that's not the end of it. Now, when you are preparing your director's report, extract of annual return will be forming part of that director's report. So, for the listed companies now, their annual report, the size will increase. Because a separate form MGT 9 has been specified for this extract of annual report, which has to be, annual return which has to be enclosed with your board report. So, major departure again, if you see, earlier it might be known that after end of every 5 years, we were required to give in detail the shareholding pattern in your annual return. Or once in a 6 years as a thumb rule. But now thing has availed and now each year full details are required to be given. So what are the penalties now? For the company, minimum 50,000, maximum 5 lakhs. Officer, imprisonment of a term which may extend to 6 months or a fine which shall not be less than 25,000 but which may extend to 5 lakhs or both. And for PCS also 50,000 but which may extend to 5 lakhs. So just see the scope of work now as a professional, how much challenging it is going to be. So now coming to the third part of our presentation, an annual general meeting. Section 96 of the New Companies Act mandates every company other than one-person company to hold a general meeting every year, known as its annual general meeting. This is the same concept as was existing under the old Companies Act. There should not be a gap of more than 15 months between the two AGMs. The first AGM shall be held within a period of 9 months from the closing of the first financial year, as against the 18 months from the date of incorporation as provided under the old Act. This is a new requirement. Now this is time limit has been given. What is the time duration during the day that AGM has to be held? Earlier also it was given over there, but there was no clarity. So now they have given the time frame between this to this only you can do your AGM. Every AGM should be held during business hours, 9 AM to 6 PM under the old Act. The term business hours was used without actually specifying the time of business hours. So I don't think some case like would have happened, but if there was a novel professional who likes to innovate with the law, he could have come out with the interpretation business hours. It's not defined its business hours in India or outside India. I am a small company, all my operations is outside India, so I will do my AGM as per that. Right? That was a possibility. I don't know if this would have happened like that, but now to stop some innovations, they have come out with a specific time limit. The meeting should be held on any day that is not a national holiday. Under the old Companies Act, the term was not a national holiday but a public holiday. So now all gazetted holiday of the central government will be immune to that. Venue. The meeting should be called at a place falling within the area of its registered office. Departure. What are the major departures? Under the old Act, in terms of section 166, public company or a private company being subsidiary for public company and a private company could fix the date, time and venue of the subsequent AGM. In the case of public company through your articles, and in case of a pure private limited company by way of shareholders resolution. But now we cannot do that. For example, in this year's AGM we cannot decide next year's AGM time, date and venue. That was possible under the old Act. So that exemption of flexibility has been given. Let's come to penalty for AGM. The company and every officer of the company is in default shall be punishable with a fine which may extend to 1 lakh rupees, and in the case of a continuing default, the fine extend to 5,000 rupees for every day. So again a Lakpati penalty. EOGM. So extraordinary general meeting. Now who can call it? The board of directors of the company can call it, which generally happens in some exceptional cases. Board may call an EOGM when a requisition has been given by the shareholders holding at least 1/10 of the paid-up capital having a voting right. And companies not having share capital by the board or requisition of members holding at least 1/10 of the total voting power. So what are the vital changes in respect of the EOGM? Under the new Act, no provision has been made for adjournment of EOGM held in pursuance of section 100. In the old Act, if EOGM was commenced within a period of 3 months, 90 days that is, then the same could have been adjourned to a date after expiry of the 3 months. That thing cannot be done now. If a EOGM has been requested by a member, then it has to be held within a period of 90 days. Earlier, there was a possibility in the 84th or 85th day to hold an EOGM and you then adjourned it. So now that thing has been removed. Under the old Act, where 2 or more persons were holding any shares jointly, the requisition or the notice of the EOGM signed by at least one of them had the same force that it had been signed by all of them. Now there is no such provision. For example, if there is a person, 5 persons holding one share, so one of them signing was more than enough. But that thing has been removed. Now all 5 will be required to sign that requisition. Eligibility criteria for convening the EOGM and passing the resolution therein to be satisfied for each of the resolutions separately under the old section 169 has been dispensed with. So this is more like a liberty or a liberal flexibility which has been given under the new law. Now let's come a thing which is related to the EOGM and EOGM that is a very fundamental thing, that is the notice. So when any meeting has been decided, a notice has to be issued. So what are the key areas under the new Act which has to be taken care of? Now the section clearly 101 says that 21 clear days notice If you see under the old act, the word clear was there. It was to be understood, but it was not given in black and white. But now that clear word has been given. So much required clarity. Then option of sending notice through electronic format has been provided as a cost saving tool. You may say that. Now you may also send your notices by electronic emails and all that. Consent for shorter notice. As you might be aware, under the old Companies Act, there were two threshold limits for giving consent. In case of EOGM, at least minimum consent of at least 95% of the members was required, and in the case of the AGM, 100% consent was required at a shorter notice. So now what they have done away with the two slabs, they have removed and they kept a one slab of 95%. So in other words, for EOGM it remains the same, but for the AGM from 100% it has come down to 95% consent. Every notice should specify the place, date and the hour of the meeting and shall contain a statement of the business to be transacted at the meeting. Electronic notice. Now, when we are sending an electronic notice, what type of compliance we are required to do, or what things should be there in order to be a valid notice? The subject line in the email shall state the following: the name of the company, the notice of the type of the meeting, AGM, EOGM, what type of meeting it is, place in the date on which meeting is scheduled. So in the subject line, that thing should be there. Otherwise, it is not a valid notice. Now, a new requirement is there in the case of the general meetings, whether it be AGM or the EOGM, notice is also required to be sent to the directors of the meeting. Earlier it was not given on the old act. Material facts. This is section 102, equivalent to the erstwhile section 173 of the Companies Act. As per section 102, a statement setting out all the material facts concerning each item of special business to be transacted at the meeting should be annexed to the notice of the meeting. So now, what are some of the vital aspects which should be getting covered over there? Nature of concern, interest, financial or otherwise, if any, in the respect of director, manager or any other KMP and relatives of such person is required to be given under your explanatory statement. Where any items of business to be transacted at a meeting of the company relates to or affects any other company, then the explanatory statement shall also specify the extent of shareholding or interest in that other company of the every promoter, director, manager or KMP of the first mentioned company. So two types of material facts is required to be given. One on the individual basis of the directors and the KMP, and other is, let's suppose there is a case of a transaction of the business which is affecting a holding subsidiary, holding associate. Material voting power is there, or influence or benefit can be there. So for that thing, the second limit is applicable. Non-disclosure. Where as a result of the non-disclosure or insufficient disclosure in any statement is being made, then any benefit which will be arising to such promoter, director of the KMP or the relatives, whether directly or indirectly, shall then such persons or individuals will be holding it on behalf of the company and shall, without prejudice to any other action being taken against them under the Act or other law for the time being forced, be liable to compensate the company to the extent of the benefits received by them. So it's very vital, you see, whenever we are drafting that explanatory statement, every material facts relating to the directors, KMP or the company structure should be getting captured over there. Otherwise, when you are auditing, you will have to give your qualifications. Penalty. 50,000 rupees or 50,000 is the minimum, or 5 times the amount of benefit accruing to the promoter, director, manager or KMP or any other of his relatives, whichever is more. So let's assume that if it is a related party transaction, a big transaction, then 5 times of that. Quorum. So how do you conduct your AGM or EOGM? What is the minimum threshold limits? Are there any change, old act versus the new act? The answer is yes, there is a change for the public companies, and 5 members present if the numbers of members is 1,000. So up to 1,000 minimum 5 members are required to do an AGM or EOGM. If it is more than that, 1,000 to 5,000, then it will be 15 members present personally. And if it is more than that, then